This is Michael Popok, Legal AF. We'll get another loss for Donald Trump today in court in the Judge Chutkan presided over D.C. election interference case. Remember, about a month ago, right around the holidays, Donald Trump didn't like the fact that Jack Smith was continuing to progress the case as he could, within the limits of the fact that the case itself had been stayed by Judge Chutkan, awaiting the D.C. Court of Appeals to decide whether Donald Trump has presidential immunity for criminal conduct or not, based on, of course, the panel and Judge Pan of the D.C. Court of Appeals. It's unlikely Donald Trump will ultimately be found to have presidential immunity for conducting the criminal conduct at the heart of the indictment. That issue will then go on fast track up to the United States Supreme Court. But in the interim, you got the underlying trial case that's been put on ice by Judge Chutkan, but not entirely. Donald Trump is upset because Jack Smith, in order to keep the case moving towards a potential March 2024 trial date, but get ready, buried within the order is a reflection and a comment by Judge Chutkan that indicates that it's unlikely that the March trial is going to go forward. I'm going to explain that to you as well, and that you will give ample time for Donald Trump and the team to get prepared, that she doesn't expect them to be preparing right now while the appeal is going on. But she also doesn't expect that Jack Smith is just going to sit and let grass grow under his feet, not continue to provide discovery that was already ordered or that was already due to be produced. She just has one issue, and that's why she granted Donald Trump's motion only in part. She did not find that Jack Smith committed any kind of contempt or contumacious conduct for which he should be sanctioned at all. She made that quite clear. I'm going to read from the order in a moment. But she said, listen, as it relates to motions that are substantive in nature, that would require Donald Trump's lawyers to look at them carefully and decide whether they are inside or outside of the stay order, for instance, or they have to be separately appealed or something like that, why don't you come back to me first as a trial judge and ask me for leave to file such a motion, and we can have some litigation over that issue. Again, not violative of the stay. These are issues that are collateral to a stay order, to a pin being placed into the process. The judge says, why don't you do that? So she denied the heart of the motion, which she expressed at the top of the order that she just issued, opinion and order, dated today, just about an hour ago. She said the motion states as follows: to remedy this outrageous conduct of the prosecutor continuing to file on the docket things that Donald Trump needed to respond to, the court should issue an order, according to Donald Trump, to show cause why the prosecutor should not be held in contempt, required to withdraw their motions, and assess the monetary sanction. And the judge says, yeah, the heart of that motion, I'm not doing any of that. The plain language of my order said that things that I compel, things that I order, things that are required don't have to be responded to. Doesn't mean that Jack Smith and special counsel can't continue to provide documents and information. But again, buried in here, and I want to manage expectations. The judge knows that all the time that it's taking the D.C. Court of Appeals, I already thought they would have ruled already, and therefore baking in a further delay with the U.S. Supreme Court, it is not going to happen that this trial is going to take place in March. Maybe it's April, maybe it's May. But she doesn't even think. Even the Judge Chutkan doesn't think it's March. Let me read to you from the relevant provisions of the order and comments in the order. I'll tell you why I'm coming up with that. And so she made clear on page 2 of her order that the court emphasized that the stay order that she put in place, because immunity goes to a foundational issue of jurisdiction for the court, that the stay order held in abeyance but did not vacate deadlines and proceedings, and that requiring additional discovery or briefing, maintaining those measures did not advance the case towards trial or impose burdens of litigation on the defendant. And so therefore, she said that the things that the government did, producing additional discovery, filing motions in limine to preclude certain types of evidence, eventually for trial, She looked at both of those things. And she said, first of all, from a civil contempt standpoint, he has to show willful noncompliance with the court order and then the ability to compensate with monetary damages for that violation. And the judge says on page 3 that her original stay order did not clearly and unambiguously prohibit the government actions to which the defendant objects. She says, start with the operative sentence, which only stayed, quote, the deadlines and proceedings scheduled by its pretrial order as amended. It's similar to a hot take that I did on this very issue. It's only the deadlines and proceedings that she scheduled, which are scheduled by a court, not unilateral conduct by the special counsel's office, voluntary conduct that she did not require. That was not stayed. Are you self-conscious about your smile due to stains? Are your teeth aging you? Popular food and drinks are known to stain teeth. Beverages like coffee and wine stain them over time. So what can you do to brighten your smile? Well, you should give Smile Actives a try. Smile Actives is safe, effective, easy to use, and will keep you smiling proudly. As you probably know because of all the videos we do, I'm a big coffee drinker, and over time I noticed my teeth lost some of their brightness that I was used to seeing. 97% of Smile Actives users in a clinical trial reported up to 6 shades whiter on average, all within 30 days. Simply add Smile Actives Pro Whitening Gel to your regular toothpaste. It's been formulated with PolyClean technology to boost stain removal and deliver active whitening ingredients into teeth's grooves and crannies to get better whitening. Smile Actives makes a teeth whitening gel that can simply be added to your toothpaste every time you brush your teeth. So no change in your routine, no extra time, and no more messy strips, trays, or lights. People will start commenting on your whiter, brighter smile in just days. Smile Actives is the whitening boost your favorite toothpaste needs to give you the smile you deserve. Visit smileactives.com/legalaf today to receive a special buy one, get one free offer with auto delivery plus free shipping and handling. That's smileactives.com/legalaf. Terms and conditions apply. See site for details. She goes on to say that the rest of the stay order also did not unambiguously forbid the government's actions. Defendant Trump claims it contained an explicit holding that additional discovery and briefing would violate it. And the judge says on top of page 4, that is incorrect to Trump. The stay order reasoned that requiring additional discovery or briefing, again, back to my original analysis, would advance the case towards trial or impose burdens of litigation on Trump. But then she goes on to say, but neither the court nor the government has imposed any such requirement. In other words, the operative term there is requirement. And that the government's productions, the judge says, and filings are mostly compatible with the stay order's broader purpose, which is to relieve the defendant from the burden of preparing for trial and pretrial litigation. Now she turns to the motion practice and she said, you know what, on the motion practice, that has to be properly evaluated by opposing counsel on Trump's side. And so I'm going to clarify. And she says as follows. Because the stay order appears to have been interpreted differently by the parties, the court will clarify. Quote, if defendant Trump wishes to raise objections to the government's productions, he may do so without any risk of forfeiture if and when the mandate is returned from the appellate court and the court sets a new schedule. Contrary, and this is the key about why we can now have confidence that the judge is not expecting Donald Trump to be preparing the case for trial. I had thought that the judge would expect them not to be letting grass grow under their feet and to be preparing for trial in March. But here, listen to these words. Contrary to defendant's assertion, that's Trump, the court has not and will not set deadlines in this case based on the assumption that he has undertaken preparations when not required to do so. In other words, you're wrong, Trump. I don't think you're preparing for trial now. I know that you're not, and that's consistent with my stay order. She then quoted herself and said, quote, a trial start date of March 4th, 2024 gives Mr. Trump 7 months before indictment and trial, which I believe is sufficient time to advise with counsel and prepare his defense. She quoted that, and by quoting that, she's telling the rest of us that while she thought that the 7 months was enough time, She understands that she put a pin in this a month ago and that he's lost one of those 7 months. She's going to have to reset the deadline. She's going to have a new trial order that reflects the fact that Donald Trump has been running in place, and she's okay with that in not preparing for trial while the appeal is going on about whether the indictment should be dismissed on immunity grounds. So that's really the headline here. It won't be the headline outside of the MeidasTouch network, but that's the headline. Trial judge acknowledges the trial is not going to happen on March 4th. She's going to have to reset those deadlines and did not expect Donald Trump with the stay in place to have been preparing for trial. That's my major takeaway, buried for other people on page 4. In the meantime, she went on, Trump, is not required to carry any meaningful burdens with respect to those productions. And then she ended it with the motion in limine or motion practice. And she said, well, that one is substantive in nature. So she agrees with the contention that diligent defense counsel for Trump will need to conduct a preliminary review of each substantive motion that the government files in order to know whether they need to take any action. And while it's not a major burden, it is a cognizable one. It is a real injury. Accordingly, the court will adopt Trump's recommendation that the parties be forbidden from filing any further substantive pretrial motions without further leave from the court. Any such motion for leave to file shall state whether the proposed motion is ancillary to the side of the pending appeal and so requires a timely response or other actions before the mandate is returned. This measure is in addition to the stay order, and it does not reflect, the judge ends the order with, a determination that the government has violated any of its clear and unambiguous terms or has acted in bad faith. And so what that means is, and this is going to sound counterintuitive, the judge is going to allow additional motion practice about whether a motion should be filed and require Trump to participate in it so he can argue that he'll be burdened if he's participating in the motion practice. Did you follow that one? That's federal court practice for you, folks. And that's where we are at the end of this hot take. Good, reasoned, sober decision by Judge Chutkan. We expect nothing less from her here on Legal AF. And that's where we are right now. I'm sure Donald Trump won't like that. He'll have to decide whether he wants to take that issue up to the Court of Appeals while they're trying to decide whether he's got immunity as a former president or a then president from criminal conduct indictment. We'll follow it. One place. Don't change that channel, MeidasTouch. Legal AF. We sit at the corner of law, politics, and justice. We don't blow smoke or sunshine. And we do it twice a week on a podcast we call Legal AF. And it's 8 p.m. Wednesdays and Saturdays. And then on audio podcast platforms of your choice, I do hot takes like this one about every hour at that same intersection. If you like lawyers who know what they're talking about about legal and political issues, you've come to the right place. So until my next hot take, give me a thumbs up and a comment helps with the ratings, help keep the network and me on the air. Till my next Legal AF, this is Michael Popok reporting.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.